said, Rachel, that we're deep into Shavuot. Partly, I'm noticing that because my computer doesn't automatically autocorrect Shavuot to Shavuot. Two very similar, for the first couple weeks in this Masechet, my computer was sure that I was typing the wrong word. And it is, the whatever AI runs my spell check is getting used to this Masechet, and then I feel like next year when I start to do some writing about the holiday of Shavuot when it's coming, I'll have to retrain it that actually Shavuot I type more than Shavuot. Anyways, hi everybody, nice to see you. This week we jumped into chapter 6 of Masechet Shavuot, which talks about a particular kind of oath administered in the courts when someone agrees to a partial claim of a debt. We'll talk about the details of that later. And we'll look at a text from a Mishnah from Shavuot and some background material to help us understand what this chapter is about. As a lead into that, I brought some show and tell for today that I'm going to start with. Will feel maybe a little, it's Talmud related. It might feel a little tangential, but you'll see how that comes in. I went to my Talmud reference bookshelf, which I don't use so much anymore because Sefaria is so inclusive. I want to just mention two Talmud dictionaries. One's that's on Sefaria, so available digitally to everybody, and one that's not. And the one that's not, we're going to turn to a little bit today. But if you're a linguist and interested in Talmudic Aramaic and the language that the rabbis use, the go-to reference book, I'm going to hold it's blurring. I'll put it in front of my face, then it won't blur in the video, is the Jastrow Talmud Dictionary. This dictionary is on Sefaria. It's the go-to place if you see an Aramaic word and you want to know more about it, what it means, how it's used, what its root is. This dictionary, which is almost a century and a quarter old, is the go-to place for Babylonian Aramaic, and was an essential study guide in the days before translations were as available as they are today, especially in academic settings. What I love more and more on Sefaria, I think, when you hover over Aramaic words, sometimes like the hover feature in Sefaria actually brings up the Jastrow definition. And it's a very useful tool, especially if you're reading and you look at the translation and you say, oh, this translation makes sense to me, but I want to see how it matches up to the words. Jastrow can be very helpful, and I love the fact that it's there in the reference section on Sefaria and easy to find if you're surfing there. So I wanted to show that today. But the dictionary I'm gonna turn to in a moment is the Practical Talmud Dictionary. If you notice, just in terms of size, and that's like Jastrow is bigger and thicker, this is a smaller one because it doesn't cover every word in the Talmud. The Practical Talmud Dictionary was brought to us by Yitzhak Frank for rabbinical students, around the world who are English speakers. Very few people call it the Practical Talmud Dictionary. It just took on the name of its author, the same way the first one, Jastrow, we call Jastrow after its author, right? This lovely volume is often referred to just as Frank, because Yitzhak Frank is the author. I love that, it has a name. This book is named Frank. Feels like my pet rock named Frank. But what I love about the Practical Talmud Dictionary is, thank you for those links. They're now links to the books if you're looking to build this shelf of your library in the chat. What the Frank Dictionary does is it takes the technical terms of the Talmud, the ones that repeat regularly, that knowing what they mean helps you not only understand the word, but helps you know what the word is going to mean for the structure of the argument. Right? As we know by now, if you've been with us for Daf Yomi for a long time, certain words are cues, not just based on what the actual words mean, but they're cues to what's going to happen in the Talmud. Right? One of the most common ones that we sort of by now in Daf Yomi we sort of gloss over, right? When the Hebrew says Tanu Rabbanan, the rabbis taught, it means it's quoting a source. But implied in that introductory phrase, Tanu Rabbanan, means the rabbis taught in a Braita, right? When the Talmud quotes Mishnah era text that's not in the Mishnah, one of the ways it introduces those texts is Tanu Rabbanan. And you would learn that from looking up Tanu Rabbanan in Frank. It doesn't just mean the rabbis taught, it means the rabbis taught in a Braita, which isn't part of the literal definition of the words, but it's implied in the technical term. If you, in the days when I was a high school Talmud teacher, in fact, if you translated Tanu Rabbanan just as the rabbis taught and you left out in a Braita, there'd be a correction coming, because it's not considered a full explanation just to explain those words literally, right? Explaining how Tanu Rabbanan introduces a Braita, which means we're going to look at a text that is equivalent in authority to the Mishnah from its age, but didn't show up in the Mishnah. So it's, those that put the Mishnah together didn't include it. And knowing that gives you a little bit of a sense of what's going to happen in the Gemara. It's going to compare this outside text to the inside text from the Mishnah, and it helps you understand the flow of the logic. We're going to come back to a particular Talmudic term today that, and I'm going to show you the quote in Jastrow, from Frank on the screen, but I thought you should see these. It's, nice to know that these reference materials exist. And if Daf Yomi, your experience of Daf Yomi is leading you to study more and more in the Talmud, Frank can be it's in the title, it can be a very practical Talmud dictionary for you to use. And I wanted you to see the book. It's not yet on Sefaria. Hopefully one day, as we move to this digital world of the Jewish library, it'll be there too. All right. Chapter 6. Let me share my screen, and we will take a look at the opening Mishnah. Here we go. Slideshow. Oh, you know what I need to do? Pardon me for a faux pas here I'm going to give you the link. Oh. All right. Sorry, everybody. A technical snag. I thought I copied the link. Give me 1 second. I'll give you the link to the slides, and we'll get right back to it. Pardon me for missing that here. Maybe we'll edit this out of the video piece, the slow delay. All right, here we go. Oh, there we go. Copy link. It's coming. The link is copied. Let me go back to my Zoom screen and hit the chat. All right. Here we go. There's the link to the slides. You should be able to access them. All right. Sorry for that Zoom era pause. And now I'm going to share my screen. Here we go. And I'm going to start the slideshow. Perfect. All right. I owe you an extra 2 minutes of learning for that little technical delay. Okay. Here we go. In the opening Mishnah of chapter 6, which we encountered earlier in the week, we have this general case, or maybe this specific case that becomes like the prototype for the kinds of cases we're talking about. The Mishnah teaches us the following. If a claimant says, I have 100 dinars in your possession, and the defendant responds, you have only 50 dinars in my possession, the defendant is liable to take an oath, right, as they admitted part of the claim. Note here, I've left in bold the translation of the words of the Mishnah and unbolded the Steinsaltz commentary that helps fill in some of the information that's missing here. And this is really the kind of oath we're dealing with in this chapter. We have two parties who are coming to court. One says, hey, I gave you, I loaned you, you're holding for me, whatever, all these categories in some way or another. You have 100 dinars, that's a unit of currency. And the person, I want it back. Give me the $100 the 100 dinars that you owe me. The other person says, well, you only have 50. So here we have a difference of opinion of the amount that is owed, 100 or 50. This is a case where the court makes the defendant take an oath to say it's only 50, not 100. And the reason that Steinsaltz explains here and how we understand the Mishnah is, why do they have to take this oath? They admitted to part of the claim and not the whole claim. And so there's a sense of truth that they agree they owe some money, but they differ in the amount. And we make them take an oath either to support their claim that they only owe 50, or because of the severity of oaths and the severity of the punishment for making a false oath, as there's a hope that we can convince the defendant, should they be inclined to lie, to say they owe 50 when they really owe 100, to claim the full amount, so that there's agreement, as opposed to taking a false oath. And the oath helps us know or believe the defendant that 50 denarim is what they owe, not 100. And it's a way to settle the difference of opinion. And so we use the fear of a false oath to help confirm the truthfulness of the defendant's statement, or convince the defendant to be truthful, agree to the full amount, if that is in fact what they owe, to avoid having to take an oath. And we jump into this chapter that deals with the specific cases where the oath is required, types of cases where there are certain conditions that exempt the person from taking an oath. And we've been, knee deep in this chapter in different types of cases and whether or not there has to be an oath. But as I've been reading this chapter, there's been something nagging in my head about this Mishnah in this case, about why we don't believe the defendant when they say, when they agree and say, right, I do owe you some money. It's just not the amount you think. I owe you 50, not 100. And the reason for that, and here we'll go back to the reason I brought the show and tell. Here is the rabbinic principle that could be applied in this situation, that I took. This is old school stuff. Well, using new technology to do something old school. I snapped a picture from the dictionary and cut and pasted it into my slideshow. So there's some, I used the book here because there's no digital version of this book, but in my head, I kept thinking, why is our situation from this Mishnah not a time where the rabbis would say, this is a situation where the principle of migo applies? We've seen this a number of times in the past 5+ years when we've been studying Daf Yomi, where the rabbis used the rule that they call migo. Right, migo is really just a conjunction, since or because. Right, the literal translation, right, since or because. But that as a technical term, it means the following. I gave you the definition here on the screen. Right, this conjunction is sometimes used in the application of the following rule of evidence, which the Talmud called amigo. It goes as follows. In certain cases, the court accepts a plea of a defendant as credible on the grounds that if he or she intended to lie, he or she could have invented a better plea than the one they actually presented. Meaning, the rabbis say this: if you're coming to volunteer testimony, to offer testimony, and you're gonna be untruthful, there's a law, right? There's a statement you can make in the untruthful side that will cover your, it's taking the ethics out of it that you're not supposed to do this, but you can make a statement to keep yourself in the clear legally, separate from the unethical behavior of lying. But if you make a statement that's less good, that's less convincing, that argues your case less well, it's evidence that you're telling the truth. Because if you were going to lie, you would say the more obvious thing. Here's a classic example of that, not from our Masachet or our topic. It has to do with if someone comes to your town and says, right, a new person moves to your town, and you ask, hey, who are you? Why do you belong? They're asking, and they volunteer the information that they are a convert. The Talmud says, we don't question them about their conversion. We accept their conversion and accept the fact that they're a convert. Because if they had moved to our town and said, I'm Jewish, we wouldn't challenge that fact, right? When someone moves to town and says, "Hi, I'm new. I want to join the synagogue. I'm Jewish. I want to be here. I want to join the community." We embrace that. And since you could say I'm Jewish and not be questioned, if someone says I'm a convert, we don't open up inquiries into who converted you, how is it a good conversion, et cetera, et cetera, et cetera, because you could have just said, I'm Jewish, and you would be free from questions. And since you chose to say something riskier, um, we assume you're telling the truth because you could save yourself the trouble of that investigation had you just said I'm Jewish, where we would have just accepted it. That's an example, a classic example of how Migo works. And just to go back to our Mishnah on one slide, I look at this case in our Mishnah that says, the claimant says, I owe you 100. The other person could have said, no, I don't know. You never gave me the money. I paid it all back. You have no money in my possession. Since they admitted it to part of the claim, to say, in fact, I do owe you money. I do have some of your money in my possession, but it's not 100, it's 50. By the principles of Migo, um, we ought to believe this person and not require any other further testimony or oaths or anything. And in my head, I'm like, this is a classic Migo situation. Why is it not that this hasn't come up or we haven't explored it this way in our chapter? And that's some of what I want to explore. I'm going to answer that with the slides that are coming. But one, I guess, meta comment that's about this is, the Talmud is vast, and there are many legal principles and rules that apply. And what's challenging is for a reader, for a student of Talmud to know is which rules apply in which situations and why. Like it would be a great thing, right? Going back to life in Rabbi Goldberg's high school Talmud classroom, if a student had said to me after reading this Mishnah, but wait, Rabbi Goldberg, isn't this amigo? Why should we make this person take an oath? I would have loved that a student came up with that because they're applying this rule that they learned from some other unit to this unit and applauded them for the good Gemara thinking. The challenge is, right, it's hard to know just from a new topic, from new materials, when certain rules apply and when they don't, and why this isn't a case where the Migo rule applies. And we actually put this oath into place. And some of what it's easy to miss or forget or not notice because our chapter hasn't dealt with this question head on is why it is that this is not Migo and why it is that this is in fact a case where we make the defendant take an oath, even though we do have logical and legal grounds to say maybe they don't have to because they had a better thing to testify to if they were going to be dishonest. So we should assume they're honest. And some of this the answer goes back to the verse that the rules of our chapter is based on, Exodus 22:8, which appears now on your screen, right? In all charges of misappropriation, in cases where one person is saying, right, you've misappropriated my property. It could be an ox or a donkey or sheep or a garment or any other loss, including currency, which was the example our Mishnah uses, where one of the parties alleges, this is it. The case of both parties come before God. The one whom God declares guilty shall pay double to the other. This is in some ways a helpful verse. In some ways, it's a challenging verse because there are some things in the verse that aren't totally clear. Most of the time when this verse comes up in the Talmud, they're focused on the paying of double, right? The fine for if you're dishonest in this situation, not only do you have to pay back but what you owe, but you have to double what you pay back for being untruthful. If you notice here, this says the cases come before God. That's language that hints at you have to take an oath because oaths invoke God and God language. What's really unclear in this verse that both the Talmud and the medieval commentators don't talk about a lot directly head on is this notion that one party alleges this is it. It's a very generic sort of statement. This is it. It doesn't give us a lot of details about what this means. But this is the verse that's used to explain that in the case that we're talking about, we have a disagreement about property that I have of yours in my possession. I agree that I have some of your property, but we disagree about its value or the amount. And the claim, this is it, meaning that I say, right, this is it that I owe you, not, when you say that I owe you, that's when I need to come and take an oath. So that's the verse that the rabbis have in the background, in the background that they're thinking about it, and in the from the Talmud's perspective, also sort of in the background knowledge that is needed to sort of follow chapter 6, is a passage that we haven't encountered in chapter 6, but we did encounter when we read Bava Metzia, and the text from the Talmud I brought today comes from months and months ago, perhaps years ago. I didn't check the calendar to know what day we studied this, but it's Bava Metzia was quite some time ago, where this verse comes to play, and the rabbis make clear why it is that this is an amigo situation and why the defendant has to take an oath. So Rabbi Aptariki, one of my favorite rabbinic names in the Talmud, Aptariki. If you're having a child or a grandchild, you might suggest this to the namers that, Aptariki is a good Jewish name. We don't have it so much in our world today. Taught in a Braita. Right, the in a Braita there is not in the bolded piece because the text just says Tanu Rabbanan. This is a frank practical dictionary moment, right? Rabbi Aptariki taught this. It's in a Braita, which means Rabbi Aptariki lived in the time of the Mishnah, and this teaching didn't make it into the Mishnah, but the rabbi still drew it out here. If one says to another, I have 100 dinars in your possession, and the other says nothing of yours is in my possession, the witnesses testify that he has 50 dinars in his possession. And the witnesses testify that he has 50 dinars in his possession, that he owes the plaintiff. One might have thought that he should take an oath about the remainder, right? So here's a case where he's saying, you might think that if one person says, you have 100 of my dinarim, and the other person says, I have none, here we have witnesses who says, actually, it's 50. So it's a case of a debate between, well, I guess, 150 and 0. We might think that since there's a difference of opinion, right? Witnesses say one thing, the plaintiff says another thing, the defendant says another thing. Let's let the defendant take an oath about what's left, right? With the witnesses say 50, so we can hold them to 50 because we have witness testimony. But maybe this is a case where the defendants say it's just 50, not 100, because it's a situation where they could take the oath, and that can help us understand, believe them, and award 50 based on the witness testimony as opposed to 100 or 0, which are the other options. But Rabbi Aptariki reminds us of the verse where this is all from. The verse states, this is the verse I showed you before, for any manner of trespass, an ox, a donkey, a sheep, a garment, for any lost item with one shall say, this is it. The claims of both of them shall come before the judges. That's the verse we just looked at. This indicates that you obligate the defendant to take an oath based on the admission to part of the claim by his mouth, but you do not obligate him to take an oath based on the testimony of witnesses. Meaning, this verse, because the witnesses aren't mentioned in the verse, says where one person says, this is it, meaning one of the people who's party to the case, comes before God. The only time we administer the oath is when there isn't witness testimony and the plaintiff and the defendant, or the claimant and the claimee, I don't know if that's an actual word, have a difference of opinion. And oaths are administered when there's not witness testimony and the defendant agrees that they owe something, but not the full claim. And if this is how this verse is understood by the rabbis, this text from Bava Metzia sort of makes clear what our chapter in Shavuot is about, and shows how the rabbis derive, right? There's a way in which this teaching of Rabbi Aptariki sort of is in the background of our chapter. The rabbis derive this understanding from this verse, which is why the rabbinic principle of migo doesn't apply in this case, because we have a biblical verse that's teaching us, actually, when it's a matter of a difference of opinion about the size of the debt, we make the defendant take an oath. Why? Since here it sort of works, the logic is migo opposite. Since the defendant said, I do owe you something, it makes us suspicious that they might owe us the full amount. And it makes us suspicious that they're being dishonest by saying, I owe you less. Because, they feel like, well, if I admit to less, I'll pay off half, and I'll in my dishonesty, I'll get to keep the other half. And to prevent that, to be sure that they're telling the truth, We push them to take an oath. So based on the understanding of the verse, we're actually not using the Migo logic to say they had something better to say and they didn't say it, so we're going to believe it. We say, excuse me, they admitted to part. We're suspicious they admitted to the whole thing, and that's the reason why we make them make the oath. And we do this because the Torah demands that we do it, which means the rabbinic Migo principle, which is not as authoritative as the Torah, doesn't apply here. And we have the chapter that we've been studying this week about the particulars about which cases the oath actually is invoked and which ones we don't need it for one reason or another. All right, I'm going to stop sharing my screen and come back to you. And I think we have a couple minutes, or just literally a couple minutes left for your questions and comments. What do you want to ask?
Janine asks, is there a penalty, and is it 50, 100, or 200?
Oh, Janine, that's a great Talmud question, right? If I say I owe you, you owe me 100, Janine, and you say I only owe you 50, is the penalty 50 because that's the difference? Is it 100 because it's doubled, or do we double the full 100? Wow. We haven't dealt with that in Shavuot. I'm trying to remember back to the Bavas where these cases came up more. I believe. I want to look this up, but on one foot, given the time we have left, Janine, my instinct is to say the penalty would be, they're admitting to the 50, so they would pay back the 50. It's the other 50 that they're not paying. And if we do find out they're lying and we side with the claimant and not the defendant for the other 50, right? If the defendant is found guilty of lying, they're lying about 50 and we would double the 50. So my guess is they would pay 50 plus another 100. So the total would be 150. Right? The original 50 about which there's no debate and the new 50 about which there's a debate doubled because of the penalty. That feels like the logic to me. I'd want to go back and look it up. Sorry for not having all these details in my head, because I could see the Gemara also saying 200. But I love that question. As a Talmud teacher, like, the better questions are sometimes better than the better answer. I know, Janine, you might be curious about that to fill like the knowledge bank about what the piece is, about what the answer is. But your question like demonstrates a good Gemara learning by asking a good Gemara question. So don't quote me in court about the 150 is totally what they owe, and we just double the part they disagree about. But my instinct says that would be the answer, and I'm aware that I could be 100% wrong. If I'm 100% wrong, you can bill me 200% for my wrong judge answer, because although I'm not doing it intentionally.
All right, and if we have time for one more, there's a question which comes up periodically in this tractate about, is usually the burden of taking the oath is on the defendant. Does it ever shift to the claimant, and why?
Right. The default is that the defendant makes the claim, has to make the oath, because they're the one who's in a spot, right? I think the rabbis don't want everyone to take an oath. Although, if you go back to the verse we saw, there's a way to read the verse and say they should both take the oath. I think the rabbis try to limit how many oaths are taken, because oaths have severe consequences. There are cases that we've read about. Oh, now I can't place the page. I know I've read cases. I'm a little ahead on my Daf Yomi studies, so I can keep up with my writing for the daily. There are times where the defendant can say, I don't want to take an oath, make the claimant make the oath, where the oath switches to the other person. There's a whole level of conversation about that in the Gemara, about what conditions you need to have in place to switch the oath. I guess we start with the default assumption where someone says, you owe me $100. We accept that as the standard, and that if for the defendant, partly because the defendant, when the defendant agrees, yes, I do owe you something, but the number is different, we want their oath as a support for the difference. Since there is agreement, we sort of say there's a way in which the defendant is agreeing with the claimant, but differing on details, and we need the oath to confirm the difference in details. There are times where the defendant can, ask the court or sue for the switch of the oath to the other person. And there are lots of details about that back and forth. Rob Plass, always dependable for that. 41 talked about that some. Thank you for
Also cases where the defendant is considered unfit to take an oath, right? Qualified from oath
yes,
taking.
right. There are sometimes when you're unfit to take an oath, like it makes it not an oath situation. But there are times that it switches, but the default is the defendant is the first person to take.
Yeah. It's complicated, which is why there are many pages on this, and also periodically in this tractate, stories about rabbis studying this tractate. I think we highlighted one of them in the series,
Yes,
where where
yes,
the rabbis talk about, studying this material and then being quizzed on it themselves. So
yes. It's sort of right. It's studying earlier versions, of course, because they didn't study the version. Although one of my writer colleagues did talk about, wouldn't it be cool if they were studying it and they were studying this story, sort of a meta. You could think about the movie where they're studying it and the voice of the Talmud is their actual, that's
yeah.
kind of fun. Part of what's hard about Daf Yomi and the pace and even this class, that like there's so many of these details that a half hour is far from sufficient to cover all the nuances and all the details of any 1 week of Daf Yomi. So I love when the questions like take us broader than the text I brought, and those are great questions. And I'm finding Shvuot especially mastering the details to be able to know them, to apply them the way I would if I were a judge in court and had to do all of this, is a challenge because of all the details and all the nuances. It's tough to keep in my head anyways, especially since this is not an area of Jewish law that we use a lot. Because right, the principle of dina de malchuta dina, right? We for civil matters we follow the laws of the land that we live in, meaning whichever of the countries that you said you're calling in from today, for a matter like this about a difference of opinion about a debt or your right ownership, the civil courts in the country in which you live would settle it, as opposed to the Jewish courts. So there's a way that this is all academic in this masachet. So the stakes aren't as high. Where when we were studying Masachet Sukkot, the rules of Sukkah apply for Sukkah builders today, and keeping those in your head if you're a Sukkah builder or an advisor to Sukkah builders
Right.
are more practical. Anyways,
And it's also hard sometimes to give answers because often the Talmud doesn't give them all, right? That's for when we get to very specific questions. The Talmud is in some ways a compilation of different legal understandings. And while it sometimes gives answers, sometimes it doesn't. And so
yeah,
generally categorizing what the Talmud says, that's the job of the medieval codes, right? They make some decisions about a lot of these things, but sometimes it is hard to answer a specific question about what exactly the Talmud thinks because it's such a cacophony.
right. And not
Not
every
about
passage
everything,
in
but
the
about many things.
right, not every passage in the Talmud reflects what the law actually is. We could study a whole passage and it could be really interesting, and we could answer the question, what does this passage say the law is? But because of 12 other passages, the law is something else. Just the Talmud doesn't refer to that because it doesn't get sorted out till later.
Right. Yeah. My favorite example of this is this one guy in the mission, I can't remember who it is, who stands up and says, chicken is parv, right? Chickens don't make milk. Chicken is parv, and in his community, he thinks chicken parmesan is perfectly kosher, and it's there. It's not what any Jewish community rules today, but it's there. So
Yeah.
anyway, I think we should let folks continue on their day. We're a few minutes
Yes.
over today, but it has been lovely working with you and studying with you and learning from all of you. And we will see you next week. If you want a double dose of Rabbi Goldberg, he is running a class on the Hadron next week on Tuesday, which is that formula we say every time we finish a tractate. We'll have an opportunity to say it very soon because we are pretty close to the end of Tractate Shavuot, and that Siyum is coming up as well. So lots more opportunities to learn over the Zoom, as well as, of course, every day in your inbox. So lovely to see you all and hope to see you soon. Take care.
Okay, take care, everybody.